until your call begins.
Ladies and gentlemen, and welcome to the Attorney-Client Privilege, a Governance Perspective conference call. My name is Shantale, and I will be your facilitator for today's call. At this time, all participants are in listen-only mode. We will be facilitating a question-and-answer session towards the end of this conference, at which time you may press star 1 to participate. If at any time during the call you require operator assistance, please press star followed by 0, and an operator will be happy to assist you. As a reminder, this conference is being recorded for replay purposes. I would like to turn the conference over to your host for today, Ms. Michelle. Ms. Michelle, please proceed.
Thank you. Welcome, everybody. I hope you had a nice Memorial Day weekend and a long, restful weekend. Michelle Cooper, and I'm the Senior Vice President and Corporate Responsibility Officer for CHI, and as many of you are aware, we offer these quarterly educational opportunities for all of our market board and audit and compliance committee members, and we record them so those members are not able to participate in the actual call. They can listen at a later date, and we do archive them, so we send that information out so that if people choose to listen at a later date, they'll be able to access them. Today we're going to present on attorney-client privilege and what that means for board members in their fiduciary role. Before we start, I'd like to offer the following reflection. It's entitled, Lessons I Learned from My Dog. Love earnestly, care deeply, speak kindly. If a dog was a teacher, you would learn things like, when loved ones come home, always run to greet them. Never pass up the opportunity to go for a joy ride. Allow the experience of fresh air and the wind in your face to be pure ecstasy. Take naps, store rising, run up and play daily, avoiding when a simple growl will do. On warm days, stop to lie on your back on the grass. On hot days, drink lots of water and lie under a shady tree. When you dance around and wag your entire body, the simple joy of a long walk. Be still. Never pretend to be something you're not. If want lies buried, dig until you find it. When having a bad day, be silent, sit close by, and nuzzle them gently. Enjoy every moment of every day. And with that, I'd like to offer the following prayer. Loving God, you promise to be with us always. Help us know our work is your work, to know in the ordinary of our activity. Open our minds to attentive awareness of your presence in us, through and with us. Eyes that we may see what you wish for us to see. Open our ears that in our conversations we may hear what you want us to hear. Open our hands that we may touch as you touch to bring healing. And open our hearts that we may feel as you feel towards those in greatest need. All that we do here with Catholic Health Initiative, may holy work done in your name. Amen. Okay, we have Mike Meeks, who is one of the general counsels for CHI, who is going to co-present with me and talk about some of the legal aspects of the attorney-client privilege. We'll offer some insights into some current investigations that we're working on, and we'll spend some time talking about what attorney-client privilege means, why it's in use for investigations, and how we maintain that privilege, as well as provide opportunity at the end of our session for open questions and dialogue if anybody has any questions. So we'll begin with why are we offering this education topic? As I have been providing board education through the MBO board orientation that we provide 2 or 3 times a year through the CHI leadership, I have several questions been posed to me around, do we put certain investigations under privilege, what entail, how quickly can we share information with board members when we're dealing with investigations, what's the protocol for that, how do we make sure we protect the privilege. And so there's a real board interest for understanding this topic. So we thought this would be a good quarterly education session for our board members. We know that with the current climate in healthcare, risk of governmental investigations, even the fact that CHI is beginning to evolve to more of an operating model, the government is looking at operations at the Catholic Health Initiative level more as a consolidated effort. So we'll talk about one investigation that we're dealing with in implantable cardiac defibrillator devices, and an investigation that we have going on in about 14 of our facilities. Request and that investigation actually came in through our national office, whereas probably 5 years ago, any request that we had for an investigation typically came to the local entity CEO. We're starting to see that shift and have those come more to Kevin Lofton here at the CHI National Office. So we'll talk about why and how we invoke that privilege to help protect in some of those investigations. We all know that healthcare is a very complex arena, and just being able to comply with the various regulations that are in place has been very difficult. And sometimes we need a little bit of extra time to really dig into the regulations, interview staff members and physicians and others to really gather as much data about an investigation before we actually go forward and have discussions with the government. So we know that invoking privilege actually provides us a little bit more protection, and Mike will talk about that as we move forward. We also have an increased risk of whistleblowers. I think our last quarterly podcast that we provided was on the topic of whistleblowers and just the environment that we're experiencing in the healthcare arena, where we do have some investigations across the nation that were invoked through the use of the whistleblower or key TAM provisions, and very much focused on how we are responding to internal complaints, to complaints that come from our vendors, from our physicians, and make sure that we're helping to protect the organization and get ahead of potential issues before an individual decides to take their concern forward to the government and seek actual funds as a result of bringing forth those matters. We all know that as we continue to evolve and implement electronic health records, availability and accessibility of information, whether it be patient information, financial information, or confidential information at CHI, is much more accessible, and it's our duty at Catholic Health Initiatives to make sure that we're protecting that information. But that information being there, it's important that we understand all of, who's accessing our data, who's looking at our data, who's sharing that data. And it's easier for individuals actually to get data and understand that data. And just as an example, in the last few weeks, the government has released some physician payment data, and it's global data that just details specific payments made to physicians across the nation. We do know that many individuals have downloaded that information. They're looking at that information to determine whether there are particular physicians doing a significant larger number of procedures than other physicians across the country, and people beginning to mine that data to determine whether there's potential issues out there. So we're very cognizant of the risk that this additional data and this access to data is providing to others that view it or have access to it. We all know that board members have a fiduciary duty to protect all information that they receive and earn through their role, their fiduciary role. So we're hoping that this education session will help you understand the role as it relates to privileged information. With that, I'm going to turn it over to Mike and ask him to go through some legal backing around the attorney-client privilege.
Good afternoon. First, I'll start out by just talking about what is the purpose of the attorney-client privilege. It's used when seeking legal advice, services, or assistance with a legal matter. So only someone within the corporation will reach out to the local attorney or the attorney here at the CHI office and ask for legal input with a issue that's going on at the facility. Now, the ACP provides protection from disclosure of certain communications between the attorney and the client. It goes back to there are rules of evidence that govern how evidence is produced or required to be produced during litigation or government investigations, and so there's certain protections for types of evidence, and one thing that you can claim is that things that were done under the attorney-client privilege are protected from the discovery in the litigation or the government investigation. The A applies to both oral conversations and then hard copy and electronic documents and emails. So anything that's in the course that's under the privilege, it applies to all those types of media and conversations. And the purpose of the ACP, though, is to allow the attorney and the client to have a frank discussion about what's going on, what are the issues, and that way that there's no fear that that information will be known generally to the government, the litigation party, or anyone else that's involved in what's going on under the ACP. So, ACP, in order to claim privilege, there are several elements that must be met. These have been reviewed, and these elements have come out of many court cases throughout the year. So the Supreme Court has come down with basically some specific points. One of those is that it has to be between the attorney and the client. The attorney has to be involved in order to invoke the ACP. Protects the communication both to and from the attorney. Again, is made in confidence with the reasonable expectation that the information will remain confidential. The ACP does not protect historical facts or circumstances, and this is very key here because a lot of we are brought in, the attorneys or compliance is brought in after something has happened. So whatever's happened in the past, that may be even bad information for your investigation, that information is still out there and is not protectable under the ACP. What you can protect is the work from that point going forward. If you start an ACP investigation, work that you work on, the communications from that point forward are protected. But like I said, historical facts or circumstances as to what happened, you can't claim privilege. Now, you don't treat it confidentially and have that broadcast throughout the organization, obviously, but it still is out there and is still a discoverable fact in the case of litigation or an investigation.
And one might add to that, just as an example for those of you on the call, is many times our internal auditors, CHAN, will start an investigation, and they'll identify a potentially as a risk. They do some initial work in that. It could be, an actual questionnaire or work with management to determine just how significant that exposure is. Worked with our internal auditors to say, if you get an audit and you determine that something could be significant, we're asking them to pause to contact Mike and myself and determine whether they should continue with the investigation or whether that might be an opportunity for something that you'd want to protect until you have more time to really dig in, look at some charts, look at some cases, determine what the issues are. It just provides you a little extra time, and that's probably one of the major reasons why we initiate an attorney-client privilege investigation, is to give us time to really gather and put the information together that we would need to make a disclosure.
Thank you. Well, I'll give you one other example. We just happened in the organization before where someone other than legal or compliance goes out and engages a third-party company to come in and do an audit, and we're not aware of that, and so the auditor does work, and as Michelle says, CHAN and HCS and other vendors that we utilize, they know that if they find something that looks bad, to stop and call us to see if we want to put it under privilege. But when an organization does engages another auditor to do the work and they don't have that same caveat, then they go through and do the results and they report out something looks really bad. You can't go back later and say, oh, that should be privileged, because what is done, and that's historical data. So again, without involving the attorney, that information could be discoverable or is likely going to be discoverable. So A few points with the ACP. To ensure proper distribution within the organization and to maintain the privilege, you should not forward information and emails and things like that except at the attorney explicit direction. So once there's a report that comes out and it's sent to you, it shouldn't be forwarded to others in the organization unless the attorney explicitly directs you to do so.
Just another point with that, and many of you in your fiduciary role may be aware that if you have been involved in being updated or apprised of an attorney-client matter, oftentimes they will distribute information or may put information out there on the PowerPoint. But at the close of that meeting, they may gather that information back or not let you leave the room with it, even if you take notes at a meeting. Often the attorney will collect those notes because, again, at the end of the day, the attorney can protect that privilege, but it leaves the room and it's disseminated to other people, then we risk losing that privilege. And Mike will talk more about that in a moment as well.
Another key, no one is authorized to unilaterally waive their privilege on behalf of the organization. So if it's something that's at the board level, one board member can't just say, oh, we're going to waive the privilege. It has to be a unanimous decision by the board, or if it's something at the level of administrative where the CEO and the administrative team, but there has to be a consensus and not just one person can go out and say, oh, we're going to waive the privilege.
To offer some examples of how you use the attorney-client privilege, and I just want to stress that it is not a standard for CHI to put investigations under privilege. We really try to err on the side of caution, and if we believe that we've got a particular investigation or a matter that we need to look to, if we can do it quickly, if we know how to get to data quickly, and we know that we can rectify the situation and make a disclosure timely, we generally will not protect those particular investigations. We use it more when we know that it's going to be a long, drawn-out process. We're worried that we may have a potential whistleblower, or worried that we've got some dynamics going in the organization where we may have one physician who's disgruntled with another physician, or an employee who's disgruntled with another employee, or worried that it could leak out into the community and get in the papers or some other kind of a public relations risk. Those are the examples where we choose to invoke the attorney-client privilege so that we can keep in a very controlled environment with minimal people involved in that investigation, and the attorney actually directing each step of that investigation to give us more time to do the work that we need to do. And we mentioned the implantable cardiac defibrillator investigation. Even though the government brought forth that investigation, and they're really looking at the medical necessity of implantable cardiac defibrillator or ICD, they're looking at the timing of when those procedures are done in relation to other heart procedures. And it's a nationwide investigation initiated by the government. We at CHI still made a decision internally to protect the work that we're doing to substantiate those cases that are under review by the government, because we wanted to keep it in a very controlled environment. We wanted to work directly with a small set of individuals to really look at those cases and understand them. So we have to do the investigation does not have to be initiated internally. It can also be initiated by a government, by an outside party. It may even come through a patient complaint. It could come various avenues. But we believe that it's going to take some time to work through the issues, and we really need to dig in the data. We will protect something under privilege. Another example, which is the last one on the slide, exit interviews. Right now, the compliance team actually does an exit interview with exiting key leadership, so CEOs, CFOs, we feel could have information that we want to make sure we understand before they leave the organization. And we'll ask some key questions, like, have you asked to do anything you're uncomfortable with? Working on any internal investigation matter for which you have not shared with someone on the compliance team or an individual within your organization. We'll ask some basic questions. If they raise anything during those interviews, concerned that it may involve, a Stark violation, any kickback, a billing or coding, or, any risk, significant risk to the organization, we may privilege something through that venue as well.
Well, you pointed about, you were talking about limiting the ACP matters that we do. There's the courts, they look at that, and if they think that you should routinely put everything under ACP and it's your normal business routine, they can actually, there are actually court cases out there where the government and the courts have found that because you just routinely put everything under ACP, that it's not really following the true ACP privilege, and therefore have made some things discoverable that way. So that's why I'm very prudent on trying to look at, what really needs to go under ACP versus things that can be done quickly, as Michelle said, and be resolved through a repayment or whatever solution there may be. So, way of the ACP I want to talk about next, and there's really two ways that can happen. Expressly waived, and that's where the leadership determines that the privilege will be waived. Ask, why would you do that? Sometimes we will actually do an investigation and we'll engage a vendor to come in and do like a chart review, and it may be very positive and not really be adverse findings that we think we have there. So, say government comes in to do an investigation and they start looking around at what we have going on, it may be to our advantage to produce an ACP audit government to say, look, we did hear about this, we investigated it, and we didn't find anything that was incorrect here. So that's typically when you look at waiver of the ACP, is if it's really to your advantage to produce the documents, reports, or whatever you might have to show that actually it's a better situation than what was thought. You also can constructively waive the privilege, and this is basically doing things that really actually breach the ACP. So if you disclose any part of an ACP communication to a third party, including employees and auditors, and that's not done at the direction of the attorney-client privilege, it could be considered a constructive waiver. Produce privilege documents, that is, if we're in litigation or the government subpoenas, documents that are considered under the attorney-client privilege. If you produce those, then you consider to constructively waive unless it's an inadvertent production. So that goes back just to the process, and you can argue if it was inadvertent and try to protect the privilege and get that document back. Deposition testimony, if you're under litigation and you're being deposed, what's said in the deposition can waive the ACP. So therefore, counsel, of course, will be present if there's ever a time that you're being deposed about an ACP matter, advise you not to answer questions that could result in a waiver of the ACP. And that if legal advice is combined with otherwise other information that's for other specific business purpose. So if the attorney sends an email that has just some general business operation information in it and combines it with things that are protected under the ACP, then also may be viewed as a constructive waiver as well.
It's a couple of other ways that we've inadvertently waived the ACP is if, for example, if you were in a board meeting and you received an attorney-client privilege update during an executive session, and a member of the board were to leave that room and have dialogue with another board member or somebody outside the organization or somebody even internally without legal there and at the express direction of legal, that could potentially cause a waiver of the attorney-client privilege. And so when we're doing an investigation or even an update, you always hear the attorney at the beginning of that update talk about what attorney-client privilege is and how important it is to leave your notes in the room, to not take them outside of the room, and to not have dialogue outside of the room. We do the same thing with employees and auditors and anybody else involved in the investigation. We spend a lot of time educating them on how important their role is in maintaining that privilege going forward.
The ACP, too, is that the party that's asserting the ACP has the responsibility to show the court that ACP was met, and that goes back to those elements. But the proof is actually upon the party that's asserting the privilege in order to show the courts that, in fact, this information is being requested under the ACP. The courts always say that it doesn't or it does, but they have to weigh that out. And, it may be a battle in the courts if they say you're going to have to release something, you may have to make an appeal or something like that. But it all comes down to the party asserting the privilege. A few things that don't constitute ACP. General business advice provided by an attorney. So maybe your attorney comes to the board meetings and you're just talking about general business things and they're giving some advice on how business should operate. That typically does not fall under the ACP. Again, it should be more of a formal process talking about the ACP. You should get the information from the attorney as to why the ACP is important, how to protect it, and that should go along with that advice in order to ensure that the ACP requirements are met. Some privileged information through an attorney. The courts have found that basically just because you run something by the attorney and copy them on an email, that does not constitute ACP. Again, go back to those basic elements. Labeling a document as privileged and confidential, or ACP, is not sufficient. They help your argument that it was ACP, but just because it's on a document or an email doesn't automatically mean that it's going to be covered under the ACP. Documents that are prepared for simultaneous legal and non-legal review, again, that's kind of mixing the general business advice with the legal advice, not basically prepared and intend to be under the ACP, then in those cases there, of course, the ACP would not apply either. To the board. As I said earlier, the privilege is held by the board and not an individual board member. So the board members, one or more, discusses matters with directors or non-directors outside the executive session. You could destroy the privilege in those cases. If you allow non-directors to stay in an executive session and that person really has no legitimate business reason to attend the executive session, you could get the privilege in that instance. And Michelle talked about earlier, if you distribute AC documents or executive session minutes to non-directors, then also can result in waiver of the privilege.
And just one thing about those minutes, we get the question a lot about why does CHI advise against not taking minutes during executive session. And Mike, it might be good to talk about why we advise that.
Well, again, it's executive session and it's for legal advice between the attorney and the client. So if you document that in the minutes, those minutes, hopefully are correct, but you have a written record. There's often an argument, and I think it makes it easier for the other party if they're trying to obtain those things, to argue that those minutes are not protected. So if it's an open, frank discussion between the attorney and the board or the administration, then it should be open, frank, and we shouldn't be recording all the minutes of what happened. Generally, whatever advice is given is what we'll act upon, but we want that all recorded. So that's why we typically say you can take the minutes in the executive session.
Yeah.
We're not required to.
And generally we actually have specific verbiage on how we like the fact that the executive session took place. And just for an example, when we were going through, we just recently had a settlement in our London facility related to some REACT procedures with a physician there. As we were going through that investigation with the government and negotiating the settlement and the corporate integrity agreement, we would have several updates for our board and our compliance committee here at the national level. And as we did those updates, we would put in on the agenda that an executive session was held or would be held. And then in minutes, we would put a very short sentence that an executive session was held to discuss the status of the St. Joseph London investigation. So we made mention to what was being talked about, but we did not provide the specific details.
Yeah.
Further, Mike mentioned.
Just points on the privilege in the board. The board, of course, you guys have fiduciary duty, and you need basic information in order to fulfill your responsibility. So getting the information to you is critical. We'll talk about a little more about the investigation and the flow of information here in a few more slides. Just remember that the attorney really is the gatekeeper of the privilege. So if there's any question about, can you release this information or share it with someone or discuss it or whatever, always talk to the attorney that is leading the investigation or your local counsel to make sure that whatever action you want to take in regards to the ACP information is proper.
And then a few minutes talking about what Mike mentioned. What did you expect to hear in conjunction with an attorney-client privilege matter, especially a compliance attorney-client privilege matter? Because sometimes the Corporate Responsibility Office will be involved. Anytime it's a compliance matter, they'll be involved. But we may have a specific patient risk issue that comes through our risk assurance group. May have an executive risk that we're dealing with related to an exiting CEO or something. Those type of matters, compliance would generally not be involved, even though legal may be involved. If it's truly a compliance investigative matter under attorney-client privilege, how is the board kept informed? Well, ideally, and we always made it be done in executive session. So what we ask is that those members that have anything to do with the investigation, so for example, if it's done during an audit and compliance committee meeting or finance audit and compliance committee meeting, and you have representatives from our internal audit department there, or have members of management that are not involved in a particular investigation, we ask that you move into executive session, that those individuals leave the room, and the attorney ends the executive discussion with what does the privilege mean, what is expected of the group, and you discuss the matter. And it's absolutely appropriate at that time for the attorney and the compliance officer to go through the details of the investigation. But again, it's through the direction of legal counsel in a very controlled environment with minimal minutes taken with regards to the matter. So what the board member expects to hear, we get that question all the time about, how soon can I understand the financial impact of this matter? What are expecting to see hit the press? Is the government going to release the fact that they've concluded their investigation? And we have a lot of questions around that. And what I do want to state is CHI has taken a position through the direction of our board that as soon as we gather information that is estimable. So, we are not going to, if we're doing an investigation and say it involves a billing or coding issue, and there is a range of our potential exposure, as soon as we understand what that range is, so what would be our single damages if we were to take an issue forward to the government, or, if the government is proposing a settlement with us, we have information with the Audit and Compliance Committee or Finance Audit and Compliance Committee and the board just as soon as we have it. But again, we do not put numbers out there just for the sake of putting a number out there. And we've had personal experience of that. It was actually before I joined CHI almost 11 years ago. We were working through a settlement with the government in one of our Nebraska facilities. Management made a decision to actually accrue some dollars associated with an investigation that actually had not completed, had not really gotten to the stage where the dollar impact was estimatable or estimable. And what it is, by accruing those dollars, the government asked the question during the settlement discussion of, have you accrued for anything related to this investigation? They shared that information with the government, and guess what? The government proposed a settlement for what accrued. And so, again, even just following basic accounting principles or generally accepted accounting principles, GAAP, you accrue at the time when you can determine what's the estimated impact or the dollars involved. And so we follow that same premise in bringing forth information. Anytime we're involved in a significant government investigation, or we believe there's a significant risk to the organization, either financially, public relations, or mission, or patient quality, bring those forward immediately. We do not know the actual dollars until we have time to actually review the charts and really begin to quantify the amount. walk away from this presentation understanding that as soon as we become aware of a major investigation, the board will be notified. We've even had situations where we've had to call special meetings for various reasons with the board. Generally, any compliance matter will come up through the Audit and Compliance Committee, but sometimes we can have an Audit and Compliance Committee emergency meeting and then a board meeting 2 days later. So the timing of these is very quick as soon as we determine we've got an issue. I don't know if I missed anything on that, but.
The final thing is that, what we might ask the board, and that is, what next steps we need to take, get guidance from the board where it's needed for an investigation. But pretty well the three main things that you can expect as a board member with these type of investigations.
And then just reiterating, if a board member ever does not feel, an Audit and Compliance Committee or Finance Audit and Compliance Committee member does not feel that they are getting enough information or do not understand, the how, when, where, and why of the investigation, it is absolutely appropriate at that meeting to ask those questions. CHI is very transparent. Our leadership encourages transparency. If it's an attorney-client privilege matter, that will be done in executive session and it will be at the direction of legal, but they want to make sure that the board has the information they need to make decisions that they need to make. I also want to reiterate that CHI has taken the position that if we find anything that we're doing wrong, we will go forward with that information and correct it. We're very transparent in following the regulations, and as soon as we find that we've had a breach or an employee did not understand the regulations as written, we'll work to rectify that and self-disclose. We've always had a very strong position of self-disclosure, and we've been very successful negotiating with the government as a result of those self-disclosures.
On to the part about if you have any questions, please do that while the attorney's on the phone or in person so that you can discuss it and not risk, asking questions after executive session and stuff that could, damage our argument of the privilege. So that's really the prime time to do it is when you're still in that executive session. Ask all the questions that you would like while the attorney's there and in person, and that way we can argue that the ACP does apply and protect that privilege there.
Yeah, and then another question that we get is, if we've got the attorney and it's a compliance investigation, do we also need the corporate responsibility officer there? And absolutely you do, and the government has even published some information on the difference between the role of legal and the role of compliance. And legal really is there to represent the organization from a legal perspective. Compliance is really there to represent the organization from a mission or a core value perspective and what is the best thing to do in relation to the mission and core values. So not that they're ever in conflict because they're generally together in the same basis, but it's very important that you have representatives from both facets there for those discussions so that individuals are weighing in with their thoughts and the different operational aspects of their roles.
Right, in tandem with them. So anytime there's an ACP compliance matter, I actually issue a investigation letter to the corporate responsibility officer asking him or her to work this investigation. So they're really the persons that are out there doing the work, trying to figure out what happened, gathering information and stuff so that the attorney can actually make the legal analysis as to, what the advice will be in order to resolve the matter.
Okay, great.
Again, we kind of covered this, but, board members should not consider that boardroom communications involving an attorney are generally covered by the privilege unless there are certain formalities. And again, that basically is going into that executive session and discussing a matter that's been placed under ACP. So just, again, the general discussions in the board of business matters and things like that, just because the attorney there does not automatically invoke the ACP. Now, it could, depending on that, but as a general rule, just those discussions in the regular session of the board meeting are not going to be considered to be privileged.
And then, so just before we open up for discussion and questions, I do want to state for those of you that are listening to this webcast, if you have not been at a board meeting or an audit and compliance or finance audit and discussion around an ACP matter, count yourself blessed, because that probably means that you have not had, well, I know it means that you have not had and to rise to the level that needs to come before the audit committee or the board. So, hope is that many of you will never have to experience this, but the reality of healthcare is that it's such a complex and difficult regulatory environment. I would imagine most of you in your roles will have some experience with the attorney-client privilege as you continue to serve our organization. Shantala, I'm going to turn it back over to you, and if you can just let people know how they could ask a question, that would be great.
Sure. Ladies and gentlemen, at this time, if you would like to ask an audio question, please press star 1 on your touch-tone telephone. As if that's star followed by 1. There are no audio. Thank you.
I want to thank everybody for attending today's session. If for any reason you have any questions after you've listened to this or participated in it, please feel free to email me. My email address is Michelle with 2 L's, Cooper, COPER, @catholichealth.net, and we'll be happy to respond to any questions you might have. And then I just encourage you to continue to have dialogue with your corporate responsibility officer, and if you have any questions whatsoever, feel free to reach out to them as well. So thanks for your time today, and we look forward to our next quarterly webcast.
Thank you.
Thank you for your participation in today's conference. This concludes the presentation. You may now disconnect. Have a wonderful day.